People of the State of Michigan versus Alex Michael Matthews, 21-23694. Mr. Matthews is here for sentencing. He's appearing by video from the Department of Corrections. Mr. George is here as his attorney. Mr. Gabriel is here as the prosecutor. And Mr. Matthews had pled to a charge of home invasion in the second degree as a habitual criminal second offense, which is a felony punishable by up to 22.5 years in the Department of Corrections. Mr. George, does Mr. Matthews have any objection to continuing on video today?
No, Your Honor.
All right, then with that, I think corrections need to be made in terms of jail credit. The agent is correct in that at the time of these offenses, he was on parole. And that parole ended back in 2019. Now, he didn't get arrested on this for unknown reasons until October 29th of 2020. And he'd already been in the Department of Corrections for quite some time. So I'm saying he is entitled to 218 days jail credit from October 29th, 2020 to today's date. And that would make that 218. In addition, correct where the agent says the recommendation is that the defendant be sentenced from this period to 10 years, it should be reflective of the statutory figure of 22.5 years is what the statute would require at the top end of the score. And then also restitution was not included. It's $2,509.72 to State Farm and $1,000 for the deductible to Ingrid Velkma that will be ordered. Now the $1,000 was already paid by one of the co-defendants, so that would be between the co-defendant and Mr. Matthews. We're not going to collect that twice. That victim's already been paid, but the amount of restitution for State Farm still unpaid, and that will be paid joint and severally with each one, unless there's an objection by Mr. George to something as we go through it. So those are the additions, corrections, deletions that I had. Mr. George, did you have any?
Your Honor, I was able to meet with my client. He indicated one, and I know this is an updated PSI from a prior case. So in the older PSI under marriage, it talks about his family. At page 13, almost nearly to the back of the entire report.
Okay.
My client does indicate that he does have contact with his child multiple times a week and maintains contact with his child's mother and her family.
So just the last line where it says he does not remain in contact, it should say he does remain in contact.
Yes, Your Honor.
Okay, we'll correct that now. All right, anything else?
No, Your Honor.
Mr. Gabriel?
I have
This is
nothing.
Mark.
Sir. I just want to ask, you're not asking to correct the old PSI, right?
No. We're asking to add a line that to update the former pre-sentence report, defendant would now indicate that he does now have contact with his child and with his significant other. Okay. Thank you. I knew you were going to ask that the minute I said it, so I'm glad you did. All right, let's go to scoring. The agent recommends 150 prior record variable points, level F.
I believe that's correct.
Your Honor.
Offense variables 35, level 4.
I reviewed, I had a question about OV19, but I found that in the PSI, so I believe that's scored accurately.
We'd have no objection to the scoring, Your Honor.
Okay. The advisory guideline would call for a sentence of somewhere on the bottom end of 50 months to 125 months on the top end of the advisory guidelines. Again, I'll just indicate that Mr. Matthews' case is a unique one. He was repeatedly contacting the court and others about, I'm in the Department of Corrections, I'd like to get this matter resolved, and it lingered. And so, although that is the minimum, there is that other factor to it, and we addressed that at the time of plea. So with that, Mr. George, what would you like me to know?
And Your Honor, I hate to hit the rewind button. I know we spoke about this briefly, but I don't know that we updated the terms of the plea agreement on the cover page.
Yes, thank you. We covered that when we talked. It needs to add a term that the prosecutor would recommend a cap at the bottom of the guidelines. Not that it has to be at the bottom of the guidelines, but that it can't be above the bottom of the guidelines. So would cap at bottom of guidelines. Anything else to the plea agreement then?
I don't believe so, Your Honor.
All right. So what would you like me to know?
Thank you, Your Honor. Obviously, as we've mentioned briefly before the hearing, and as the court's well aware, I think my client is not denying anything that he did here. He understands the gravity of what he did, and he understands that there's going to be a sentence consistent with his actions in this case. Since the moment that I first met Mr. Matthews, I think his frustration was just that it took so long to get to this point. And, I'm not sitting here blaming anybody. I know it's not Mr. Gabriel's fault. I know it's not, and nobody specifically here is to blame, but I know that's been a frustration with my client. But he understands that there's got to be a punishment for what he did. Obviously, going around, and whether you're under the influence of controlled substances or you're struggling and trying to find means to get those, and you're breaking into homes, it just can't happen. I mean, it really affects a person's sense of safety and security, and my client understands that. So we would simply ask that the court give consideration for the time that my client has served after his parole sentence that he was on. I think the court has made it clear that he was absolutely trying to avail himself as much as he possibly could to get this process started, but for one reason or another, it took a while to get to this point. So we would simply ask that the court follow the terms of the plea agreement, but give consideration for that time as well. Thank you.
All right, thank you. Mr. Matthews, what would you like to say, if anything?
I think Mr. George said everything that I pretty much needed to say.
Good. Mr. Gabriel?
Your Honor, what I'd like to indicate for the record is, first of all, that part and parcel to the agreement that I reached and the recommendation I made was me being cognizant of the fact that once I got this job in January, I learned that Mr. Matthews and two co-defendants initially had cases shipped out because of a conflict. Then they came back, and then I looked at them and the dates were wrong. But what did concern me was the fact that reports had been filed and no action had been taken to initiate charges for no reason I could understand for the better part of a year. Now, at that point in time, two of the co-defendants were already in the Department of Corrections. And while Mr. George is correct, I don't think we can blame anybody. I would just say that anytime somebody goes to 3 different counties and commits multiple offenses of various kinds, they're creating a problem for themselves too. And unfortunately, Mr. Matthews was involved in that. I think right now he's serving, if I remember correctly, out of Branch County for something that went on over there. And he initially got caught up by law enforcement as a result of something that went down, I think, in Kalamazoo. So we tried to put this together, and I'm trying to be fair. I mean, I'm not trying to be a hard-nosed prosecutor here, because I did work with the Department of Corrections. And so I am being cognizant of the fact that I believe the time he has been sitting in prison awaiting this to be done, I am hopefully not naive in thinking that that's having an impact on him. And I also recognize that when the court imposes its minimum sentence, that minimum sentence is going to be added to whatever his earliest release date is on his prior cases. So that's going to be more time on top of what he's already done. I thought it appropriate to cap it at the bottom end of the guidelines, and I'm not going to argue that the court should stay there. I think this is a unique case. There should be some credit given to the defendant for the time that he's been sitting in prison, awaiting this to be brought. Some time that it took me to straighten it all out and decide who I could prosecute and how. And I just hope that when you look at his record, those prior record variables are not going to go away. And any kind of trouble that he has in the future He's going to have a 22.5-year tail now until he gets out and does a good parole. So if Mr. Matthews is serious about changing the direction that his life has been going in, this is going to be a great opportunity to prove it to all of us. Thank you, Your Honor.
Thank you. All right, Mr. Matthews, Mr. Gabrey, Mr. George all recognize this is a unique case and that you were already in the Department of Corrections for 2 years now while this case lingered here. And it is true that it happens when you have a whole series of different crimes committed across the state. It takes a while to get that up to date, but we're here now. You are resolving this with a plea to habitual criminal second offense when it was charged as a fourth. And you're also getting rid of 6 other felony cases by this plea. So hopefully you've taken care of everything that's lingering out there and are be able to concentrate on your current sentences and get these done and get out at still a young age and get it all behind you. What you need to do is pick a new line of work that doesn't involve into breaking into people's homes for money and things to supply your habit and the rest, okay? So I'm gonna order 3 years, credit, 218 days served, concurrent with your current sentence. There's a $68 state cost, $130 crime victims assessment. So the 3 years is a full 14 months lower than what your bottom of the guidelines would be. That takes into account the time that you lingered there, and then and then you're getting credit for that 218 days. So, you know, I'm knocking about 2 years off the bottom end of the guidelines to accommodate this and to take this into account. And so you can get this done and get it over with and move on. So make sure you do that. Make sure you get this all taken care of and don't do anything more and get out and go on with your life, okay? There's also restitution of, we talked about this already, $2,509.72 to State Farm and $1,000 to Ingrid Velkma. So again, that $1,000 has already been paid by your co-defendant, but if I'm making it joint and several with all co-defendants, so technically they could come on you for their share that they paid of your bill. But, you know, I've never seen that done, but it is a possibility. Mr. Matthews, you're going to get 3 forms advising of what your rights on appeal are. I'd ask you to sign 1 copy acknowledging that you received them. If you wish to appeal, you need to fill them out, return them to court within 42 days. All right, thank you, Mr. Matthews, and good luck to you, sir.